Now, the ANC has welcomed the passing of the Protection of State Information Bill by the National Assembly today. The party said the bill had been thoroughly consulted and examined during at least 65 meetings held by the National Assembly. Joining me now on the line to talk about the process is one of the key figures behind the passing of the bill, and he's ANC MP Cecil Burgess, who is also the chairperson of Parliament's Joint Standing Committee on Intelligence. He also chaired the ad hoc committee on the bill. Mr. Burgess, thank you so much for joining us on Beyond Markets. Now, of course, the bill was the source of a lot of controversy, over 800 amendments. Just take us through the rationale of the ANC of why this bill had to go through today.
Look, I must first say there's no showdown. We've done what we must do at Parliament. There are people that are unhappy, and it's their constitutional right to go and seek whatever, redress they require in order to satisfy themselves. But look, the ANC has always said we need the bill. There's lots of threats to our national security. We were quite willing to listen, and we did listen. There was a first complaint about the bill being very wide, applied to all organs of state. We fixed that, and it only applies to the security forces now. The other issue is that, people need to be aware it's a very, very limited application. It does not apply to local government and all the other institutions. We've listened and we've changed that. So there's no threat that, people or the media need to be scared that they are going to be they're going to be prosecuted. The people that are in danger are, in fact, the people that are going to classify, because there's so much checks and balances in the bill. If they wrongly classify sensitive information, are they going to be prosecuted? And there's a committee that's going to be watching over this whole process. So I think South Africans should feel satisfied that the passage that the bill traveled was very wide, it was very consultative. And as things stand now, we can't help it that there are still organizations and individuals that are unhappy. We've consulted with lawyers and advocates extensively to make sure that the bill is constitutional. But it's the right of those that still oppose the bill to go and seek redress in court.
We'll come to the potential constitutional challenges in a moment, Mr. Burgess, but just take us through what happens now, just in process terms. Parliament has signed off. Does it now go to the President and he then has to apply his mind? Is that correct?
Yeah, look, the bill remains a bill. A bill is not a law. It's a bill. It cannot be implemented. The only time it becomes a law is once the President has signed it. So until the bill has been signed, nobody can take it to court. The President can defer to court, to the Constitutional Court. But before he does that, he first has to give Parliament an opportunity to address any faults that he might see in the bill as far as constitutional matters is concerned. So the bill won't land up in court until the President signs it. Yeah. And the President obviously is going to apply his mind. I'm sure he's got the proper legal advice. He will look at it. And if these people see anything wrong, he'll refer the bill back to Parliament, and Parliament will have to deal with the issues.
Now, we of course know that South African, any law that is passed has to, pass constitutional muster. There are, of course, views that suggest that the bill, despite its widely consulted process, despite the fact that you've tried to ensure that it does comply with the Constitution, there are people who believe there is a case to be made for the matter to go to the Constitutional Court. In the event that President Jacob Zuma refers the bill back to Parliament, Mr. Burgess, what is it on the basis that it might, not go through constitutional muster? What then happens when the bill is back in the National Assembly? Would you then have to examine the particular clauses, make the necessary amendments? Just explain to us what happens in the event the President is not happy and the matter is referred back to Parliament.
The President would have to identify matters that are unconstitutional, nothing else. Okay? Then he will have to refer those specific matters to Parliament. Parliament will have to reconvene its committee to specifically sit and look only at those issues. If Parliament then address these issues, the President will then have to sign the bill. If Parliament doesn't address the issues, then only can the President send the bill to the Constitutional Court. But let me assure you, we have looked, and lawyers and advocates, they may differ on what the aspects of the law might be. But what more can we do than to consult extensively with lawyers to make sure? But if there are other lawyers advising other people about unconstitutional aspects in the bill, let it so be. As far as we're concerned, we had to do what we must do, and we are satisfied from our side that there should be no problems with the constitutionality of the bill.
Now, of course, there were many issues that had to be balanced when reconstituting this law. There was, of course, the right of the state to protect national interests and sovereignty and secrets, but also the question of access to information, the right for people to speak about corruption for whistleblowers. In making those more than 800 or about 800 amendments, Mr. Burgess, what is the lesson that the ruling party has learned about the fact that often one has various sets of rights that often bump up against each other, and that one needs to walk that fine balance so that you don't have one right trumping, the other?
Look, I think it would be incorrect to concede that, originally that the rights were not properly balanced. What we were prepared to do as a ruling party was to give in, to concede, and look at where there were views that was going to enhance the bill. You must remember, when the bill came to Parliament, it gets assessed by the Chief State Law Advisor on its constitutionality, and we get special advice. So when the bill came, it was already certified to be constitutional. But what we did, we were very much interested in accommodating some of the concerns raised. And so we enhanced these issues to try and give additional protection to whistleblowers because they were unhappy that this Whistleblowers Act was not giving them sufficient protection. But you must remember, the whistleblowers you're talking about are people that are going to be working in the security sector. These are people that are working in the Chapter 11 constitutional institutions, that's your defense force, your police, and your civilian intelligence. There's not going to be people in local government. They don't have the right in terms of the bill to classify. People working for ESCOM and working for Home Affairs, and they don't have the right to classify. You're talking about agents, people that are specialized, that are working with sensitive information. They're going to be the ones. And I can tell you, if you look at the trouble they are going to be in, if they start classifying information they shouldn't, then it's going to be a serious thing. They're more the ones that are at risk than anybody else.
Now, Mr. Burgess, of course, one is gratified by the fact that the checks and balances, as you say, have been built in. But this would not be the first time that Parliament passes a law, the President signs, a bill, the President signs off, and the bill is actually, referred, or the law is referred to the Constitutional Court and back to Parliament. We had, for example, the reproductive right bill coming back because processes were not followed. You were very confident that you have dotted your I's, you've crossed your T's on this matter. In the event that there is a constitutional challenge, Mr. Burgess, how confident are you that your case is going to be won and that you have done the necessary homework, that this bill is not returned, particularly if one considers that there is and has been precedent where in fact Parliament and the President has been wrong and the Constitutional Court has instructed you to change legislation?
Look, the judiciary is independent and one must not interfere with what they may or may not do. I'm not that arrogant to say that, you see, nobody can ever be better than what, the ANCs or what Parliament has done. That's not really our case. We got procedures. We got participation procedures that are recognized and prescribed in the Constitution. We have to follow the procedures and the processes that are prescribed in law and in the Constitution. We can only do what we must do, and we comply. Now, we've complied with that, and we have to be confident that we do the thing right, and so that we don't run into these problems that you're raising. But who are we to say? The courts are independent. They've got their own view. I can't think for them. I think it would be arrogant, it would be irresponsible of us to say what the courts may or may not do. But if the courts say anything, if they raise anything, then we must deal with it. And that's the way South Africa works today. We're not scared. You know, we're not doing something unlawful. We don't make unlawful or unconstitutional laws at Parliament, but we accept that if we are told something has gone wrong, we come back and we fix it. That's the way the ANC will see the matter.